Pleasure to be here, and thanks to all of Sherman and Howard. These are wonderful events, and I'm so impressed with the new venue. This was a new location. Love that. The sun's out, birds are chirping. Most importantly, I do not work for state government anymore. So I'm here now to give you the insider's guide to how the division does its work, to our laws and regulations that we enforce, what are gray areas out there, what are challenges for you as employers. So I'm really here now to be able to speak more freely as a consultant, as someone with expertise there, someone who's written a lot of those publications, but as you well know, there are varying quality out there within the Department of Labor and Employment, their online guidance, and a lot of them just don't speak to your questions and issues you have. So please feel free to chime in with questions as we go throughout, because I want this to be interactive and educational for everybody, and that's the way to do it. So I'll give you a little bit more about my background in the Division of Labor, what we do, and then as Andy was saying, we'll jump into the hiring hurdles. We've got employment verification law that builds off the federal I-9 that's unique to the United States. The Colorado's is completely different than any of the other 49 states, and it has not been declared unconstitutional yet. The credit history law, which we have, that was enacted in 2013, that applies to the vast majority of employers in this room as well to a varying degree. Important additional law that takes place at hiring time, usually involving applicants. And then we've got your ongoing wage and hour obligations, social media obligations to social media, again, new around 2013. And I'll talk about some legislation that's going on at the state capitol. We're about halfway through the legislative session, started in January, ends in May. So I'll give you an update there on things, at least get your finger on the pulse of what's going on at the capitol and government. Got to give you the usual caveats and disclaimers about what I'm saying. Everything's in flux at the Division of Labor where I worked, so things evolve and change quickly. I can tell you how things were in the last 12 years. I can predict how I believe they will occur in the near future, but things are changing quickly there. The investigations and hearings that occur across all those four domains that I'm going to be talking about are not open records currently at the agency. So if you want to find out how the agency's ruling on is this overtime method permissible, can I deduct for X, Y, Z, what does the agency do in these scenarios, they won't tell you, which is very unfortunate, which leaves you all unknown. If there's no guidance online, they won't answer questions over the phone, you can't get the information, what are you supposed to do? Well, you turn to legal counsel and others, experts, to try and take a stab at it. And also, concomitantly, there's very limited case law, state case law on these laws, not only the new ones, but also the old ones. There's far more case law that involves the federal laws, but I'm primarily focusing on the state. But for each of those domains that I'll be getting into, there's a federal counterpart. So for state wage and hour, we've got the Fair Labor Standards Act. Social media, we've got the National Labor Relations Act. Credit history laws, we've got the Fair Credit Reporting Act. And then employment verification law, we've got the Immigration Reform and Control Act, aka the I-9. So everything I'm talking about is state law, but you gotta remember, oh my gosh, all the federal laws sometimes conflict, they have different requirements. Of course, whichever requirement provides employers greater benefits and really imposes more obligations on you typically prevails across the laws. Nothing I say is legal advice, and jump in with questions at any time. So let's get right into my background and some of my credentials there. As Andy noted, I've been with the Division of Labor for 12 years. The last 3 I was a deputy director, that was number 2 of the agency. And the Division of Labor is one of 5 agencies within the broader Department of Labor and Employment. The department itself has about 1,200 employees. Most of those are concentrated in unemployment insurance, workers' comp, employment and training, oil and public safety. But my division was the little one that was always doing the law compliance, that labor employment law that we're talking about today. And now the agency is undergoing a reorganization. It looks like my division is now merging with the Labor Market Information Unit, which historically has provided unemployment statistics and data on pay by jobs, workforce trends. So they're deciding to reorganize. There's a lot of new staff to agencies. So combined with these new laws, you have new staff, you've got a new reorganization, and very limited outreach and education, leaving this big unknown, this black box. How do they make decisions? What do we do as employers to function efficiently within the constraints and boundaries of the law that our legislature and governors have seen fit to enact? And that's a real quick background on the agency. and what we do. And I'll jump right in with one of the first hiring hurdle areas, and that would be the employment verification law. In 2006, our legislature had a special session on immigration. You may remember it was a big focus back then. It's still a big focus now in the country. And the legislature decided we want a state law that added and built upon the federal I-9 process. It's separate, though. They're separate obligations, but they are so interrelated. And there's a website you can go to see publications on that at the state government. But in essence, every employer in this room is covered by this law. It applies to your new employees that were hired on and after January 1 of 2007. And for those newly hired employees on and after January 1 of 2007, you have to do two things. You have to complete an affirmation form, which is available on our website. For new hires after 2014, you have to use the newest version. In the early years of this law, we had varying versions. We let employers make their own versions of affirmations where you're affirming that you looked at their identity documents, you're affirming you didn't knowingly hire an unauthorized alien. But now you have to use the form just like you have to use the correct I-9 form with the correct expiration date. So you've got that affirmation form for every new hire. You complete it as employer. There's no sections that the employee completes that's a difference from the I-9. You, the employer, complete the whole affirmation, sign it, and then you also make copies of those identity and employment eligibility documents, those list A, B, C, I-9 documents. You make copies of those, save it with affirmation for those new hires, and then you retain it for the entirety of their term of employment. Unlike the I-9, once the employee is let go, terminated, fired, you can destroy all that. You don't have to retain the affirmations and copies for the state, whereas under I-9, you typically have to retain the I-9 form 3 years post-hire, 1 year post-fire, whichever is longer. So for the state, you can just get rid of it the day they're gone, and there may be a lot of valid reasons why you want to do that and not have those materials laying around. Another tip on the copies of the documents, copy the front and back of those list ABC documents, the driver's license, passport, social security cards, things like that. And those, in a nutshell, those are the requirements. So a lot of people see it and say, well, how is this different than the I-9? You're just filling out another form that's an affirmation, and you're copying the documents that are presented for the I-9. How is this different? And the answer is it's really not. But it allows the state to audit you, whereas the state's unallowed to look at I-9s. Only the federal government can look at I-9s. So the state can look at these things and request them. Feds look at the I-9s. I can't tell you how many employers send in the I-9s when they get an audit notice from the state and say, we can't even look at that. We're not auditing that. We're auditing these distinct requirements. If nothing else, it has raised the attention of employers to the importance of the I-9, which frankly is much more important than this law, and reminds them of that. Yes, we had a question.
Quick question. Electronic copies, scanned versions?
Yes, electronic copies the division does permit. Basically, the general rule there would be legible, secure. It copies the entirety of the document, the entirety of the affirmation form. We've had employers PDF on their own the form that's online, because the division didn't necessarily have a user-friendly version. Of course not. Private sector does it better. So you're allowed to make your own, save it, use it. Just make sure you can produce electronic copies. And we prefer those, actually, if you're submitting for a large new hires when you're audited by the state. We'd rather get an email than a big box of this information. Yeah?
So unlike the I-9, though, there's no remedy, right? Like if you're a new HR person, you come to the organization, you do an audit, you're missing any documents. After the 20 days, there's no way you can...
Great question. So you're exactly right. If you don't do those two things within 20 days of hire for this individual, you cannot correct it. So if you're hearing me today, wow, we're not following this law, we're not doing this at all, do not go back and create these documents and do these for pre-existing employees. Once you've missed that 20-day new hire window, you can never do it. Now, there is a good answer that I'll be able to tell you in terms of what happens if you haven't been doing it correctly. But you're right. You don't go back and redo it and correct. You did it in 20 days, or we view it as never having done it. And so what happens is essentially you've got those affirmation forms and you've got copies of ID, employment eligibility documents. So if you receive a letter from our division, look, you're being randomly audited or you're being subject to a complaint, the vast majority of our audits are just random based, over 7,000 since 2007, about 9,000 total audits done. So we're doing a lot. We're hitting a lot of employers. We do generally use statistical algorithms to choose employers completely at random, or we take complaints. Complaints cannot be anonymous. We make sure there's some underlying basis for the complaint before proceeding, because we don't want to have just competitors filing complaints and doing investigations based upon animus and competitiveness. So you get that letter. You've got to submit those documents for all your new hires on and after 07 that are currently employed. And if you look at our rate of compliance, well, 63% of employers in our first audits fail. And most of them, the common reasons and denominators there would be they just don't have the materials. And let me take a step back there. So here's what happens on a first audit. This is your first time ever you've heard from a division. You get a random audit notice. If you just tell us honestly and truthfully, look, I didn't have the information, didn't know about this law, you will not get fined. You will not be subject to a fine in the first audit. We generally have to establish what's known as reckless disregard, showing some level of proof or intent. You knew about the law and you consciously disregarded it. So in a first audit, just be honest. Don't fabricate. Don't try and create things. Don't not respond or feel paralyzed. Just tell us you don't have it. And what that means then is then a few years later, you'll likely be re-audited by the division. And at that time on a re-audit, for any new hires since that first audit, if you didn't comply fully, or at least at, say, the 87.5% level, then you'd be subject to a fine. And the fines range approximately a few $100s per form or per copies per employee. So we did levy some significant fines over time, but they're more commonly done just because employers fail to respond. If you don't respond to the audit, we'll fine you the max. If you backdate or provide us fraudulent information, if you write on a 2014 form that you filled it out in 2008, that's a problem. That's backdating. And I got to tell you, that's our most common action by employers. And because they get the letter, they don't read it, they just go to the website, they download the form, they fill it out quickly for everyone there, and they submit it. Well, that's not going to work. So don't do that. Just be truthful, and you'll be safe. Any other questions on the employment verification law? It's a new one. There's a few employees that devote full time to enforcing it, and it's gone surprisingly swimmingly as far as enforcement goes. Yes?
For the record restriction, while the employee is current, you have your affirmation. Do you attach the I-9 behind it with the IDs behind that?
That's a phenomenal point. Where should you physically save these items, electronically or in hard copy? And there's pros and cons there. The problem is if you keep this with the I-9 and you get audited by my agency or you get audited by federal counterparts, it's going to be tempting for you to submit all that to that agency. And we've had a surprising amount of times where we've conducted an audit and they've already given it all to the feds or vice versa. So there's arguments to keep them distinct, shred them, and keep them different at different times. Those copies are not required under federal law. It's voluntary to make copies of those ABC documents for the I-9. Although they would argue once you do, it's probably their property too. So there's pros and cons here. I would keep them separate.
Okay.
And that helps you in audits, and it helps you remember different schedules. And there's really no reason to keep this information around for state law longer than you have to.
Because I know with the Department of Homeland Security, you have to keep the IDs with the I-9.
Yeah.
But so you're saying it's okay to keep?
Well, the state just wants what we request. So the question is, are the feds going to get angry if you gave us or got rid of the copies that they would have liked for the I-9 but weren't required in the first place? And that just depends on the federal government's stance. I can tell you, they're not doing a lot of I-9 audits right now. They were doing a lot more a few years ago. So, that's wax and wanes along with the political ties that we all deal with. But you're statistically far more likely to be audited by us in Colorado than you are by them, if that's any consolation.
And then once they no longer work for the company, you keep all of the records for a year.
Well, I-9 is 3 years post-hire, 1 year post-termination, whichever's longer. And if you want the really good guide on I-9 procedures and practice, they have a handbook called the M274 online. Download and use the M274. You've got to be doing the I-9 completely correct in order to then do the state law. Because if you're copying the wrong documents or you're specifying documents when it's the employee's entitled to present them, you're already violating I-9 law before you even get to our supplementary requirements. So get your I-9 ducks in a row, and that's what this law is kind of good for too. So let me move on to another hiring hurdle that takes place early on with applicants. And this is the Colorado Employment Opportunity Act. Some may debate that title, but it generally prohibits you as an employer from using credit history information, credit scores, for employees or applicants, and I'll use those terms interchangeably because they're basically the same in this law, unless they're specifically exempt from the law. This passed in 2013. We were about the 10th, 14th state in the country to pass one. It's a new trend. The proponents of the law argue that your credit information really isn't a good predictor of job performance. It's rife with errors, and that it just shouldn't be included, maybe due to medical bankruptcies beyond your control. So the legislators and the governor presumably just didn't want credit history being used in employment decisions with limited exceptions. So it covers vast majority of employers in Colorado. Went into effect 2013. It was amended in 2014 to add a couple exemptions. But there's two prongs of this law. Essentially, you can't request credit reports or information or use it for employees or applicants unless it's substantially related, that's a legal term, to the work and job they're going to be performing or will perform that they're applying for. And so what does substantially related mean? It means that the position itself must be one of these four positions. So you are allowed to get credit information for executives, managers, officers, and then this more nebulous concept, employees who constitute professional staff to executives and managers. Those of you in the legal realm, with legal knowledge, that is a term of art that comes from Colorado law, a non-compete law. So if you get involved in litigation or have a big issue, what does that mean? Look to non-compete case law to understand who professional staff are. But essentially, you can get credit reports if the individual or applicant is in one of those titles. They're not defined beyond that in our law or rules, so you would have some leeway in arguing with the agency if someone constitutes that or not, if a complaint comes up. But the position must be one of those four things, and that position must involve one of these four responsibilities. This is a simpler test. I'd argue if you're executive manager, officer, or the professional staff to them, you're certainly engaging in one of these four, so this is a lesser concern. I mean, every employee has a fiduciary responsibility employer and access to information. So that one's ancillary and much less important. So if the position involves those aspects, then you can obtain, yes?
Yeah, just a quick question. What about corporate credit cards? Or issuing corporate credit cards? Is that fiduciary, would that make it something? If it's not their credit card, you want it to be.
Well, if that individual is part of that process and their position did constitute one of these.
May not know.
Yeah, well, you need to meet both prongs of this test. So the position has to be one of these four, and the person in one of those four positions has to do at least one of these four things. So you can't just match this test, but just be a front desk worker. You know, so this law is a blanket prohibition on obtaining and using credit information for your frontline workers that have no managerial responsibilities, no officer executive responsibilities. So, and unless it matches another exemption. So here's the broad industry type exemption. Those were position exemptions. These are industry exemptions. So state and local law enforcement, yeah, we can do whatever we want. The private domestic services or farm and ranch labor. Then we've got, let's see, the less than 4 employees, so a really small employer. The banks and financial institutions, that was clarified in the 2014 amendment. They can do this with any employee. So bank tellers, they could do it on, even though they're not management executive, what have you. And then other intelligence services. So it's like I hit something here. Ideas here. Remember, I've been with the government for 12 years. So, now, assume you are permitted to obtain and use a credit report for these employment decisions. You then must also, there's disclosure requirements. So even though you can use it, you've got to then disclose in writing to these candidates that you're going to get it, you're going to use it. These are all above and beyond or separate from those Fair Credit Report and federal requirements under that law. And the law doesn't describe how it should be disclosed, but you need something in writing to the applicant, look, I'm going to get it, I'm going to use it, and it's because it's substantially related to your job. That would probably suffice. Yes?
Only during the new hire process, or would this also apply to a person transitioning within the firm, or is it something that we haven't done in the past, but we want to implement going forward?
Yeah, this applies to current employees for promotion, reassignment, retraining, applicants, everybody at every phase. And so we're looking here, if you take an adverse action, even if the employer was allowed to do it for that employee, they were allowed to get the report, they used it, you then have to disclose to the employee or applicant the reason you used it and the information you relied upon in making the decision. For example, Pete, you applied for this job. We were allowed to get your credit report because you're going to be a manager. We got it. We looked at it. You had 20 bankruptcies. You're spending all your time in Vegas. We didn't hire you for it, and we got to put that in writing and give it to you. That's what has to happen there. So there's new adverse action disclosures. And here's the common complaints the agency is receiving. We've got individual is denied based on the report. Just the employer asking for it. The most common situation I see when I present to audiences is that employers are asking and getting these when they just can't even do it. That's just, you can't do it. You can't even have it on the application. So if those positions aren't exempt or your industry isn't exempt. And then of maybe lesser offense was when they were allowed to get it and they got it and they used it. They just didn't tell them in writing what they relied upon. So you can think of a spectrum of infractions. And all these laws, there's a spectrum from the worst in this law is to get it when you can't get it and then use it when you can't use it. And then maybe from a legal standpoint or evidence standpoint, have that in writing that you got it and used it and you shouldn't have. So we've seen that, and those are easy to adjudicate by the division. And this happens a lot of time from multi-state employers who are using some form or third-party service that they just think the state laws are the same or they haven't updated, and it only has maybe California on there, not Colorado. So in terms of enforcement, the law, this 2013 law solely provides a complaint process with the Division of Labor. There's no separate private right of action enumerated in the law. So we would investigate. We've got complaint forms on our website. Actually, all these laws I'll talk about, we have complaint forms, we have fact sheets, we have processes. Go to the site. A lot of those I was placed in a different role in writing. So we would investigate, hold hearings of appeals, not huge penalties, up to $2,500 to the prevailing party, really unique in employment law. Technically, the employer could be the prevailing party, and we could penalize the employee and try and have them pay you. I don't see the agency ever doing that, but you know, if the employee files a complaint, the employer is completely complying with the law, and it seems frivolous, and they're wasting your time. And if the employer wanted to pursue penalties, maybe. But bottom line, $2,500 goes to prevailing party. That would usually be the applicant or employee. And the danger here, it doesn't sound like a lot, but let's get back to what an offense is. If you're doing a hiring process and you have hundreds of candidates, and you've all of a sudden impermissibly requested their credit information, those could be individual offenses, so it could stack up, even if we only hire them for one or two jobs. I don't see the agency taking that perspective in the short run, and right now, as of when I left, they're solely reactive to complaints. They're not doing random audits under this law due to resources and other factors. Any other question on credit history? Yes?
So if we do business with, we have government contracts, sometimes we're, prime, sometimes we're not. And sometimes our clients require our employees to have some background checks done in order to work at their site or with them on a contract. So let's say we have employees in that situation and then they fail that screening. Now, we don't know because it's the clients that are conducting those investigations, so we're not getting those consumer reports. But let's say an employee fails, but their employment with us is contingent on them being able to do that work.
Yeah, there's a few different layers.
And if we're not privy to the details of why they're not approved for?
Yeah, there's two different layers there. Are you truly the employer? Is there an employment relationship there with you? Are you the one liable? And then also, is that maybe somehow exempt with contracts with defense, intelligence, national security, space agencies, or the federal government? The extent of that, the law really just uses that language. It doesn't elaborate on it. So maybe, I mean, if I were you, you're arguing there was an employment relationship, we weren't responsible for that check, or that somehow you're exempt under this contract issue. Beyond that, it would be speculative really for me to say how the agency would look at that, but it's a good one. It's a good one to talk to your attorneys about too. Yes, Bill.
So does this apply just to credit history and credit reports, or does it apply to background reports of the kind we reporting?
Yeah, the agency thus far has, in the last 2 years since it went into effect, has viewed this solely about credit history information, has not expanded the reading of this law into the criminal background history, and has not expanded it to say salary history or things like that. So it's been narrowly tailored at the agency just to look, are they trying to get a credit score or credit report? And a surprising amount of times we found where employers were clearly violating federal law, because under federal law you have to give them notice and information about their rights if you want to get a report. We had a lot of instances where employers just somehow managed to get their credit reports without the employee even knowing, and then using them and having this in writing. So they just kind of skipped a couple of federal steps in the first place and were violating our law. So be careful with that. But we're not expanding to criminal, although I'm going to bring that up in terms of the possible proposed legislation, the whole ban-the-box criminal history type laws that may be arriving to Colorado soon, or at least on your radar. Let's take a quick switch now to wage and hour. This is the biggest domain historically that the division is engaged in, and you may be familiar with the Wage Act and the minimum wage order and all those things. Most recently, the notion of wage theft, which we can loosely define as any time you don't pay your employees in a timely fashion all earned wages, you've engaged in wage theft, whether it's intentional or not. That's the new term. Our legislature passed in 2014 the Wage Protection Act, WPA. That's what I'll be referring to. That's what your chart's about. And it was in response to a variety of advocacy groups and studies that show that a lot of people in Colorado may be underpaid or not paid at all for their work as employees. None of what I'm talking about applies to independent contractors. There has to be an employer-employee relationship. And certainly from looking at audits, I would put this up there even more so maybe than the employment verification law audits. When we audit employers in wage and hour, which primarily are reactive due to complaints, not random because we don't have the resources, we're always seeing infractions. And it's because wage and hour law is really, really complicated. You look at the federal law it's based on, there's 1,000 pages in the Code of Federal Regulations on wage and hour law, thousands of federal wage and hour letters. Then you've got state wage and hour laws, rules, and regulations that differ by each state tremendously. So the legislature passed this law to try and beef up enforcement from my agency, give money and funds to really step up enforcement of our laws, notwithstanding the fact that they're still really confusing and gray in a lot of ways. Now, this law I'm going to be talking about, this is the adjudicatory process. It's new to the division. Only applies to wages earned on and after January 1, so it's a little over a year old. And you can essentially view the division. We used to be doing mediation, conciliation. We'd exchange letters, but we weren't levying fines and penalties. We just didn't have the resources. Now the law mandates the division. In these circumstances, you will be penalized. You will have to pay this. This will have the force of law. We've added a hearing officer position. So it's a really new, unique procedure. It's kind of like a small claims court. And this is where, although maybe I'm much more structured than that, actually. This is a good time to take a look at the chart. If you have it with you, I'll just walk you through the salient points. Sorry it's so busy and complicated, but I tried to get it all on one page. And it's sort of a walkthrough of what happens. And so you're an employer here in Colorado, and what can happen to you, and I'll talk after this procedural stuff, I'll talk about the types of law that it's related to, minimum wage, overtime, that. But this is the process, the new process. So starting in the top middle, a current or former employee files a written complaint with the division for wages less than $7,500. This process is only entitled to employees who allege less than $7,500 is owed. Now, we do an investigation, we find that, say, $50,000 is owed. That doesn't mean all the work is for naught. It means that the division could only compel the up to $7,500, but they may note the other amounts in their decision. At that time, the employee may go to court. So It was designed to emulate that limit in small claims court of $7,500. The work had to be performed in Colorado. We look at the last 2 years, 3 years of willful. So now under the law, keep your pay statements for 3 years since the day it was earned for all employees, because you'll have to produce that. And they file a complaint on our form. We've got online forms, PDFs, or instantaneous submission. We don't take anonymous complaints for this process. And here's the trigger date, another very important trigger date for you. If you get that notice of complaint from the division, or you get a separate written demand for wages ever from an employee, you have 14 days from receipt of that demand to pay them everything owed, or you're going to be liable for fines and penalties down the road. So anytime you get a written demand, even if it's kind of vague, I think I'm owed wages. As of this date, I'm pretty sure I'm owed overtime. You deducted something from my pay. Those could be construed as written demands, which trigger a 14-day window to respond and pay everything owed. And then, okay, the division sends you that notice. We get information from you. They pre-screen the complaints. And at the lower left, the green, we look at no violation by the division. We decide you did everything right. At that time, it would be dismissed, but the employee could do one of two things. They could either appeal the decision to our hearing officer, new position, and then the hearing officer would be sort of like UI hearing officers, where they likely do telephonic hearings primarily, look at the evidence, get more evidence. They're loosely bound by civil procedures. They're not strictly bound by court procedures. Or, most oddly, what the employee could do, whether the decision was a violation or no violation, they could say, I don't like the division's decision. Let's start over. I'm done with the division, and I'm just going to go straight to court and start over. So the law provides the employee this unique ability to kind of throw out everything we did and start over. Now, this process here is not required either. Employees could skip the division altogether and just go straight to court. So they can either go to division first, court first, but if they go to division first and don't like the answer, then they can start again in court. Kind of unique. And they can always appeal to our hearing officer. If either party doesn't like the hearing officer's decision, that then is appealable to the district court. So, new formal adjudicatory process. Throughout the process, anytime you fail to respond to the division, that's a new $250 fine for each non-response. So, for example, we send you a notice of complaint, you didn't respond in 14 days to us, that's a $250 fine. The more significant new fines, and fines come to the division, penalties go to employees. New important fine is a $250 per employee per month pay statement fine. So this is a real important one. You want to make sure your pay statements contain the right information. You have them for 3 years for all employees, because pay statement transgressions can be $250 a month per employee, maximum $7,500 per individual. That's brand new in the law as part of this. And thirdly, the one that could be the most, conceptually the highest, is you can be fined up to $50 a day since the date of non-payment of wages. Say 2 years ago, you deducted $100, unfortunately, from the employee's pay, and you were just wrong. We ultimately look at it. That could get up to $50 a day since that date for that. That's very, very much discretion of the division on those amounts and when they levy it. But the penalties, which are probably more concerned and practical in the short matter from my knowledge of the division. Penalties are the greater of 10 days of pay or 125% of the wages owed, whichever is greater if we find that you owed them the wages. So under the worst case scenario in this law, you owed them $7,500. 125% of $7,500 is about $9,300. So you'd owe them $7,500 because you just didn't pay them right. $9,300 about for penalty, and then potentially tens of thousands in fines too. So it's added a lot of new fines and penalties. It's a unique new process. Upon ultimately rendering a determination where employer owes fines, it's likely the agency would send you to state collections for the fines, and it would be incumbent upon the employee to pursue their wages and penalties through their own collection methods. The agency will not formally attempt to collect what the employees are owed. We just run the process, but they're kind of on their own, like in some courts. So that's a real quick run through on what this new law has done. Prior to this, we just weren't issuing fines and penalties. Yes.
Peter, the law uses the term willful in 2 places.
Yeah.
Statute of limitations and increasing penalties. How has the division been interpreting what it means to be willful?
Great point. The willful can boost up the the penalty by 50%, and I glossed over that. So to this date, right now, the agency is not really using willful, and I think in the future, if they tack on that 50% multiplier, I think it would require that specific employer had already failed audits by the division on similar issues previously. So it might look at previous knowledge that the division has on that issue, and in the absence of that, probably would not render it willful. Now, some people would just argue, well, look, if you don't pay minimum wage, you should know what minimum wage is, and that's willful. You're paying someone $1 an hour, willful. They could take that tack, but thus far they were not doing any willful.
So the division's not adopting the standard under the FLSA for what's willful?
In terms of how they're applying it in their daily work, no. One other good note to at least minimize some of this, so once that agency renders that decision and says you owe X amount in wages, you have 14 days from the issuance of that citation and notice of assessment to pay what's owed. And if you do, they have the ability then to lower the penalties by 50% and to waive or reduce all the fines. So if you can see that the division is right after that first investigator ruling, I did owe $1,000, I'll pay it right now. Basically, the fines will generally go away, and the penalties will be reduced 50%. That was the practice during my time. So there is some fair-handedness there. I've got some more descriptions here of this process, but that again just reiterates everything I said. Here, as of my departure just a month ago, they only have one hearing officer, and like I said, there's so many new employees there, so everything is new. Everything is precedent-setting, and there's a lot of backlog in this process, and that's what I'll turn to now. So how does this look every year, and how likely are you to be audited by the division? Starting at the left here, the agency gets about 6,700 total inquiries a year, and this is data I got from the agency. This is for calendar year 2015, so it's pretty current. They get about 6,700 total inquiries, but that includes emails and other writings. But if you look at total complaints, 4,400 written complaints. But of the 4,400, only 3,400 of those fell under the new law. In other words, the wages were earned on and after January 1 of 15, because that's the jurisdictional kind of start of the new law. So we had 3,400 Wage Protection Act complaints in 2015. About 3,000 of those were reviewed by staff and others. So at the time I got this data, there were 400 that were kind of still in the earlier phases. Here's what's really interesting, because the law, they passed such a strict regimented law that takes away a lot of discretion from the agency. One thing we did was we set up a pretty strict screening process where when we get the complaint, we're right away looking at, was it work in Colorado? Was it in 2015? Were you truly an employee? All these other issues. 1,500 complaints were dismissed because the complainant never followed up with our initial inquiries. They submit a form online. It usually doesn't include vast majority of what you need to know as an investigator. It's using, hey, employee, give me more, answer these questions, give me time cards, give me time sheets, fill this out, whatever. So almost half of those complaints gone, employee never responded, and only maybe 30 or 40 of those ultimately did they follow up. So a significant portion of complaints now are being dismissed early on because of tighter screening by the agency. Now assigned officers, those are assigned, means assigned investigators. Say 11, and now we're down to 1,100 that are assigned to an investigator. They send out 300 times they send out notices of complaint. 200 times they send out extensions. The law requires the agency to complete an investigation within 90 days of sending out the notice of complaint. If they don't, they have to send you a letter telling you, sorry, we're extending it. And they can say that pretty much for any reason. So a lot, because of their backlog, because it's all new, there's going to be a lot of extensions, so don't be surprised if you're ever involved that it takes a long time. But ultimately, hopefully, it becomes more efficient and quicker than courts. At least that was the goal of the advocates. About 170 were dismissed for jurisdictional issues too. Dispute notices involve where the employee submitted the complaint. We give the information to the employer contests their finding, gives new evidence, so it's just kind of further on in the investigation. About 116 $250 fine notices. Those are employers who just didn't respond to the first letter or any letter at any time within 14 days usually. 105 of the complaints were in Spanish. Very small amount compared to the talking in the public and amongst various groups about one of the goals of this law was to help the low-wage individuals, bilingual community, and others that may be underserved or scared of the court system. We actually get pretty few complaints in Spanish, although we have 3 full-time bilingual compliance officers in Spanish. And then as of this data for 2015, there have been 8 formal determinations that went through the whole process: investigation, citation, notice assessment, was employer right or wrong. So statistically, hopefully, I mean, this will obviously change as it becomes more streamlined and learned, but a lot of the complaints get screened out. A lot of complainants do not participate in the process, and it's just interesting administrative procedures going on there. Let me move on to, so this whole new process, it covers our Wage Act, our wage order. We take a lot of calls at the agency, and so feel free to always call them and email. I can't say right now that you're going to get a lot of information when you call or email beyond see this information on the website, do that. You know, they can't give legal advice. They can't apply the facts you're providing to a scenario in the absence of a formal complaint. So you're really not going to get a lot of information beyond what's on the website. For the top areas, I always saw at the division that are now eligible for the process: final pay, overtime, deductions, contractually promised pay. This is different than federal government typically looks just at minimum wage and overtime on minimum wage. Colorado will look at, you promised me $20 an hour and you only gave me $15. That's something the division does. It's different than the federal government. Same thing with commissions, bonuses, and vacation earned in accordance with the terms of any agreement. It means it's important to get your agreements in a row in writing and ironclad, so it's very clear. And that's true with deductions. So it's really clear what they're entitled to, when, what they're not entitled to, and what they may owe you. Off-the-clock work is huge now, of course, with social media, 24/7 technology, all that. Our current minimum wage is $8.31, and tip minimum wage is $5.29. It went up 1% since last year. We're one of those states now that adjusts automatically every year to inflation or deflation. We're the only state in the country thus far that actually lowered minimum wage when we saw prices decrease around 2010 or 11. But that's where we are now, and make sure you're complying in those domains. And I do want to highlight deductions some more to just reiterate the importance of the written agreements. Our law only allows deductions in the areas that are listed in the law. If it's not listed in the law as permissible, you cannot do it. So just be really careful what you're deducting for. We see employers all the time that are deducting for issues that may be just the cost of doing business. If you want to deduct for theft, you always have to file charges with law enforcement. That's stipulated in the law. You can't just say, I've got them on video, here it is, division, they stole it, I'm not paying them. No, file charges with law enforcement. And then upon termination, you have a broad ability to make deductions, but again, it's probably always better to have that in writing than to just say they absconded with various materials and items and just take it out of their last pay, because that type of action on your part sends them to agencies like the Division of Labor, you know, those disgruntled employees. Yes?
So I have to have them sign the actual document that talks about we can deduct because for these things, because we have a lot of out-of-state and they might take computers. So we always have that done in orientation.
Yeah.
That way they have to sign anything, right? So what do you do with, if it's in a handbook, does that protect you? Should you have both, or if you have the language in your handbook that they're signing off on, will that take care of it?
Yeah, and regardless of the location, a signature is a great thing. In writing is great. Here's what we provided you on what date, and here's what happens if you don't return it in the appropriate condition at a certain time. So that tends to fall into the, look, this is starting off in employment. You've got a written agreement. That's a loan, advance, a pay, a good, or service. In loans and advances, you're in a dangerous place unless you're a bank. I probably wouldn't support giving out lots of loans and advances to your employees. That's one we just always see that comes back to bite employers when employees leave suddenly, and the employee, you know, an employer in their goodwill is giving them all, you know, trainings and information and other great things, and the employee just doesn't pay it back. So be careful with deductions. And if you work in one, now deductions fall under the Wage Act. The Wage Act applies to every employer. Yes, Henry?
A quick question about deductions. This is not in your slide, but the statute says don't make deductions below the minimum wage.
Yeah, I was trying to gloss over that too, so, sorry. This is a very important point, but it does highlight how the agency just doesn't have good guidance, and you're in a tough spot. The last sentence in the agency, in this part of the law, says that nothing in this section authorizes a deduction below minimum wage as portrayed in the Fair Labor Standards Act. Well, first of all, federal minimum wage is different than our minimum wage. They're at $7.25, we're at $8.31. Notwithstanding that difference, it says none of these deductions can take you below minimum wage. But it doesn't say whether that's net or gross. So, well, wouldn't we argue that, well, taxes, of course, they're a paycheck, we're not saying they have to get net $8.31 an hour. Taxes can go below, and so can garnishments and child support. But then why can't all these other things, too? If we're saying one prong can bring you below $8.31 in net pay, can't we do that with all the rest? So the agency's never been clear on what that really meant to have a floor of minimum wage. Whether that floor, if the strict reading of the statute, is the federal minimum wage or state, I'd argue the state makes more sense. The statute doesn't make any sense to be talking about federal. But when they wrote it, we weren't adjusting, so it was a strange situation. So be careful when you're deducting. Be careful with the minimum wage. And that one, certainly I could talk to some more of you after the presentation. Probably need to move on right now, but it's a great point. Be careful on what's minimum wage and what's taking you below it net. Now, if you work in one of four industries, you're covered by additional protections in Colorado, retail, service, they're all listed there. And this is where we have our unique 12-hour overtime standards for work performed in excess of 12 hours in a day or consecutive hours without regard to starting any time of the day. So if you're in one of those four industries, you've got unique overtime standards for those non-exempt employees. Similar, but some different exemptions to FLSA exemptions, like the white-collar exemptions. And those non-exempt employees are entitled to rest and meal periods of either half-hour meal periods when their shift exceeds 5 hours or 10-minute rest periods for every 4 hours of work. Again, just non-exempt employees in one of those four industries, this is what they can get. The rest periods are always compensated, but the meal periods are uncompensated if they're truly relieved from duties and free to leave the premises. Yes?
I just have a question about the rest period.
Yes.
Those expired, like, we had lots of discussions with the rest of the Department of Labor. We get, every time I'm on phone,
Yeah.
what the laws are, and then I get police following up.
That's a great point. And what you're talking about, when you're getting different answers when you call up, that's called compliance officer shopping. Call the agency, talk to one person, get one answer, write down the name and time, call them back 3 hours later, talk to someone else, get a different answer. So very common. I'm familiar with that. And, here's my perspective, and I'm no longer there, but certainly I worked on this issue for many years. The rest, you don't have to mandate that your employee take a rest period and schedule it. If the employee is not seeking it out and everyone's happy, that's fine. But some employers where they've got a more contentious relationship with their employees, they're worried about litigation and the wage and hour side, they feel we really have to schedule these and document it. And same thing with lunches. Even if the employee doesn't want to work through the lunch, and even if it's not great for the business, we're going to do this because we're afraid. And that's on the spectrum of risk-reward. But you don't have to schedule times. You don't have to make them take a rest period. They're not entitled to smoke breaks. That's another one that comes up a lot. I want my smoke break. No, there's nothing in the law that says you have to get 10 minutes at a certain exact time, and nothing that says the rest periods have to be off the premises. But the meal periods are a little bit more onerous in that to not pay them, you really have to discharge them from all duties and not have them interrupted during that half hour for it to be non-compensated. But the law or the regulation actually does also provide that if the nature of your activity exists such that it's impractical to give a meal period, you're running a small retail store, they're the only person there. We're not shutting down the store for half an hour so they can go out for lunch. You can require them to work through the meal period as long as you compensate them for the time and allow them to eat on the job. So there's a lot of twists and turns on the meal and rest periods.
You have to provide them an opportunity to take a break at some point.
Yeah, that's a great point. You have to provide the opportunity, but they do not have to avail themselves of it.
So,
And that's true with both.
okay, so I have a business where I have a dog daycare, so it requires a person to be in the dog. So I have to, by law, provide someone to go in there to relieve a person to leave if they want to leave. Right? So that, by law, do I need to do that? If I don't want them eating food with them?
I'm sorry?
So I'm saying I have a doggy daycare, so it requires like a certain person to be watching a certain number of dogs for a
Sure.
certain amount of time, right? So in order for me to give them a break, someone has to go in. So am I required by law to provide them that opportunity to break, or can I say, I don't have time at this moment, I can do this later? I mean,
Yeah, I mean, the 10-minute rest period, the rule does not define when it has to occur, so there's a lot of flexibility there. But it does generally say you want one everyone 4 hours for 10 minutes. That's entire what the regulation says. But we can follow up some more after. Let me get on to a couple more topics. And I'm here after the presentation. I also have my email on the first slide. If anyone wants to follow up on anything, I'm here for you, even though the government's not paying me anymore. And so in terms of ongoing obligations, new law, this emerged around the same time as the credit history law. This is talking about social media, a hot topic. The legislature loves to throw out things and feel like we're on top of things. Social media is a big thing, so we've got to issue laws. Doesn't apply to Department of Corrections, state and local law enforcement, but basically applies to every employer in this room, I imagine. And there's 3 things you can't do now in Colorado. This is new. We're about the 10th state in the country to have one of these. They're also known as Facebook laws. 3 things you can't do with employees and applicants. Same thing. Use those interchangeably. Can't ask them for passwords and usernames to their personal social media accounts. Can't have someone apply for a job and say, open up your computer, type in your password to Facebook, I want to see all the goods. Another one that's maybe more like, now we haven't seen thus far any complaints like that, it's just really exceedingly rare. But the employer cannot mandate the employee add the employer to their list of contacts. So that's one you got to be careful of. You can't tell the employee to add the employer and employer's agents onto their private social media. And the one that we've seen most common is you can't mandate they change privacy settings on personal social media accounts. I'm not talking about business accounts. And the one we most commonly see is they're telling employees, make your site, your service private. We don't want to see what you're doing on Saturday night. We don't want our clients hearing about you, reading about you. So make all these settings private. You can't do that now in Colorado with employees and applicants. And this is, but you can, of course, access anything that's publicly available online. There's other legal reasons why you may or may not want to do that. And also think about the National Labor Relations Act. But under this law, at least, you can access publicly available online. And then there's some other exceptions to situations where you may be able to access it. But the thinking here by the advocates in the legislature was your private sites online are like equivalent to a personal journal, and there's no reason your employer should have access to it and read it and see it, no matter how much they may be interested. And if you violate any of those provisions, someone can file a complaint with agency. It's the sole remedy in the law, just like with the credit history law. They come to the Division of Labor, file that written complaint. Here's some of the information we're seeing. Really, turning the privacy settings private was the most common. We've had very few of these because the law is new and it took us a while to get things up online and get things going. And here, instead of penalties that go to the complainant or the employer, these are just fines. If you're found to be violating this, they would go to the general fund, the government. So the complainant would get no benefit whatsoever other than satisfaction of penalizing the employer. And again, as like with credit history, on the social media side, beware, because if you send out an email telling all your employees to do one of those prohibited practices, that could be a lot of offenses in one fell swoop. One email could be hundreds or thousands of offenses if you told all your employees to change their settings or never allow people to view X, Y, Z. That's a summary on the social media, and a quick one. I know out of time here. The last few slides, and that's why I gave you the bill numbers and what happened. These are just sort of an interesting take on where we are in the legislative session. They're more entertaining than really a good indicator of what's going to happen with the laws, but I'll just take 1 minute and go through really the core of each one real quick. So this one's a pro-franchisor, franchisee bill, protect franchisors from all of a sudden having this employment relationship that's a concern now in the law. That's introduced, no action yet in the legislature, so it's still out there. Another bill to prohibit you from looking at salary history of applicants unless they volunteer it. Now remember, for all these, we have a divided legislature, so we've got the Republican Senate and Democratic House, so a lot of these, not a lot of chance. They tried to repeal that employment verification law. The division oversaw that was killed in February. And yet, then they did a separate bill that still exists. That's let's replace that employment verification law with mandatory E-Verify, the federal government program. Some other states do that. That's still alive, but probably not going to live. Division of Labor being renamed to Division of Labor Standards and Statistics. So when you hear that in the future, that was what Pete was talking about today, or some amalgam of those terms. Attempt to require paid sick leave for all the private sector is a big one, national media and nationwide. That was killed. Permitting local government minimum wages. Our state right now by statute prohibits cities and localities from having their own minimum wage for the private sector. This tried to repeal that so Boulder could have a higher one and anyone else who wants it could do it too. That was killed and it's not going to happen there. This employee leave to attend child's academic activity, that's gone the furthest of any of these bills. That's reenacting a bill that expired 2015. It's essentially unpaid leave to attend child's activities for a certain amount of time. So we'll see that one, I think, of all these could pass, potentially pass. 9's brand new. This would recognize the CDLE and the Department of Labor and the governor would recognize good employers who have all these family-friendly policies and procedures. There's a long list of them in the bill, but they would create a logo and a plaque and a website, and you would be listed as a family-friendly employer if that passed. But I don't think there's any financial benefit other than the goodwill and the marketing aspect too. And the government's got to spend time working on that. 10's the most entertaining of all these to me thus far, which was killed, but the proposal was if you retail food service, i.e. a restaurant, if you didn't provide 5 paid sick days a year, you had to post on your front door or main entranceway a public health notice. This establishment does not provide 5 paid sick days to employees, and accordingly, they're likely to be sick, et cetera, et cetera. So that one did not survive, obviously making a point on that one. And then they tried to reestablish the Pay Equity Committee, which died out a few years ago, and that was a working group in Colorado comprised of government and other private individuals to examine pay equity issues and issue reports. So that died out. And then on the list that haven't been introduced, that are possible, if not this year, maybe next year. Let's see them get rid of that inability to get information from the division. I want to know right now how they're ruling on these cases. I want to be able to look at this information. If this was public information before this presentation, I would have gathered every determination I've ever issued, looked at them all, got common themes, and been telling you about it, but we don't know. It's a black box. Now, ban the box, that's the prohibit criminal history use, just like the credit history, but now we'll expand that to criminal history use and employment decisions. That will be coming up, don't know if it'll pass. And then potentially the right for private sector employees to inspect their personnel files as defined in the law. So all 3 of those are maybes, the others are out there. I know we're over time by a wee bit, so any last questions? You want to adjourn and anyone can talk to me after, or what do you like? Well, thank you all very much. I am available.
Thanks, everybody. Peter will be here for a few more minutes if you have any questions. And, of course, I'm here and my colleagues from the department are here. So if you have questions about wage and hour law or other issues, please feel free to come up and speak with us. And we hope to see most of you in May. Thank you.
So I will see you hopefully.
And what is your first name?
Patricia.
Patricia, I see Harvey.
Oh, yeah.
Harvey, okay.
Yeah.
All right.
Yeah, and you're Carol.
Carol, yes.
So I know it's going to be a huge
I
conference,
know,
so we may or may not run into each
Where are
other.
you staying at?
Downtown, I can't think of the name of the place. But I know they said we could walk.